There ain't nothing more powerful than the odor of mendacity.
And welcome back Inside the Law. I'm your host, Philip Holloway. Welcome. Today we have a very special edition because back with us here Inside the Law to help us make heads or tails of the Fani Willis versus Young Thug trial, as I like to call it, because let's face it, it is Fani Willis versus Young Thug. But she may not be in the courtroom, but this indictment against these YSL defendants, this massive RICO, is her baby. Fani Willis, as we know, loves giant racketeering cases. And so this is one of the ones that she decided to drop sort of early on in her tenure as DA, prior to the one that, of course, got the world's attention, where she indicted former President Trump and so many others on another giant racketeering case. But this is Inside the Law. This is, as you know, the place where we come to learn about the real justice system, not the one that you may think that we have from simply watching TV or even the cable news stations. But, you're getting the perspective of myself and, of course, my guests who are practicing lawyers, many of whom have had decades and decades of experience. I've had over 30 years myself. Not all of that as a lawyer, but as a police officer and then later as a lawyer. And so I know a little bit about the real justice system, and we want to learn about the real thing from the cases that are in the news every day. And the one that we've been following and the one that's really, really hot in the news that everybody's following right now is this Fani Willis versus Young Thug trial. So without further ado, put your hands together and a big Inside the Law welcome, please, to attorney and my friend and colleague, Doug Weinstein, who is one of the architects of the removal, shall we say, of the prior trial judge. He really, really, really went to bat for his client, went all the way up to the Georgia Supreme Court, and ultimately brought enough pressure to bear on Chief Judge Glanville to inspire Judge Glanville to allow another judge to consider his recusal. And of course, that recusal was granted. Good afternoon, Doug.
Good afternoon, Phil. And thank you for saying all the nice things about me. That was a team effort to get Judge Glanville recused. But yeah, we fight for our clients, as I'm sure you do as well. Or as I know you do as well.
Well, look, I mean, thank you for saying that. Look, I can't begin to say how inspiring it is. And, it makes me tired watching you guys, because I see my friends and colleagues that are stuck in this courtroom now for months and months and months and months on end, and no end in sight yet. And I go to other courtrooms around the metropolitan Atlanta area to various calendars. And so you'll have Judge so-and-so maybe in Cobb County calling a case that, let's just say it's a Brian Steele case or a Bruce Harvey case or a Doug Weinstein case. And they go, oh, they're still tied up on that giant monstrosity down in Fulton. And that's how it's referred to commonly in the metropolitan Atlanta areas, that everybody knows you guys are tied up with this giant monstrosity. So we know that from this past week, Doug, and you were on recently, and thank you for that. But since then, a lot of things have happened in court. So what I would like to try to do is, since you were there, I want to play a quick video. And I want to then ask you to talk to me about what it means and sort of what happened at the end of the week. By the way, your motion, Doug, before we play the video, let me ask you this. Your motion for a mistrial, can you tell us what the current status is of your motion?
Sure. Best as I can figure out, and I think this is accurate, all the other motions for mistrial have been denied thus far by the judge, except for the one that Max Shart filed 2 days ago on Friday. Judge Whitaker, mine has not been ruled on, and Judge Whitaker said this week from the bench that basically, this is what she's doing this weekend, or at least a part of what she's doing this weekend, is coming up with an order regarding my motion for mistrial. Now, of course, I would like to think that she is going to be ruling in our favor, but given all her other actions with respect to planning for the return of Kenneth Copeland, how are we going to instruct the jury, etc., I imagine she's planning on ruling against us. However, who knows? Maybe she's had to take the weekend and she's struggling with it, and in trying to deny the motion, she will decide that we're correct. But I will remain hopeful. But I think anyone who has watched the proceedings over the last week would give betting odds that she is going to deny the motion. But we'll see. We'll see. I keep checking my emails.
Well, we talked a little bit offline before we went live about some emails that you got, and to the extent that you can discuss any of those, we'll do that. But let me show this video from of Brian Steele. And by the way, folks, Brian is he's not standing maybe in front of the microphone so much. So turn your volume up so you can hear the courtroom sound. But when Doug and I come back at the end, turn it back down so it doesn't blow your ears out. Okay, here we go.
Copeland said at that point in time in front of the prosecution is something that is Brady material. Impeachment. Okay. Impeachment. Okay. And therefore Brady. Okay.
So that's why I wanted to put.
All right. Thank you.
And call the prosecutors. Now, they may say that didn't happen, and I assume that's what they're going to say because they would have a Brady obligation to run out and say, June, this happened, this man said this, but they didn't say that with anything, so I don't trust that the Brady was being complied. That's why I asked you again today, please, can you put some teeth into Brady, because Mr. Copeland did say on the record, I'm a liar. That is Brady. That's like the greatest Brady.
Well, you got that, so.
But I got that because.
I know, but you have it now, so it's not Brady, just like you just said.
But my point is, it was hidden on the 10th. How about that? By Judge Glanville and the prosecutor. They knew about it because they were in the room when that was discussed. That's objectively true. So anyway, I'm just telling the court, I was not there. I don't want to make specious allegations against anyone. That's why I want to get it right. And that's why I asked you to have an evidentiary hearing.
Okay.
I believe that there's Brady evidence. I have a good faith belief. I'm telling you everything I know. I'm told that it's not privileged, that Miss Bumpus, Miss Hilton, Mr. Copeland spoke, and it's not in the transcript, and Mr. Copeland was talking about his information on the killing of Donovan Thomas. Because you have to remember, in the statements, he has himself not involved. Mm-hmm. He has himself learning about through another person.
Right.
And my understanding is that is not what he said. That's inconsistent on June 10th, and I did not get that from Mr.
All right. So you can turn it back down now so that we don't blow your ears out. But Doug, what it's my understanding from everything that I've learned, and by the way, I'm not able to, unlike you who is stuck there with no choice. I'm practicing law and I've got other things to do, so I can't watch every minute of it. So I'm having to go back and kind of piece it together. So I want to make sure I get it right. But it sounds to me like Brian wants to get some testimony, and he's still got a lot of questions about that ex parte. So can you help us understand what he was talking about?
Yeah, let me clarify something to the best of my ability that seems to be confused in the public discourse.
All right,
regarding the ex parte meeting that took place on the 10th. We did, as everyone knows, after 3 weeks, after 3 weeks of asking for it, we did finally get a transcript of most of that ex parte meeting. What we got was a transcript of the portion of the ex parte meeting where Judge Glanville was present and the court reporter was present. And so we have that. It is my understanding that at times Judge Glanville and presumably the court reporter were not in the judge's chambers or that room, and there was a conversation among Kenneth Copeland, his attorney, Caleb Bumpus, as well as one of the prosecutors. I'm not going to name the name because at the present time, I cannot remember whether it's Miss Love or Miss Hilton. But they were in there talking together. And it is my understanding that at that point, without it being transcribed, that Kenneth Copeland made a series of admissions that would be Brady material, that would be impeachment of Mr. Copeland. And some of those admissions, as you heard Brian Steele say in open court, so I'm not saying anything that's not in the public record, Miss Love and Miss Hilton.
We know they're going to watch, right? We know
anyone else,
watch.
anyone else that wants, anyone else that wants to report me to the bar, made admissions regarding the murder of Donovan Thomas. And I'm not going to say where I heard that from, but I heard it from a source that would know. And they being the state, would have an obligation to let us know about that. So I think you hear Brian Steele referring to that. Brian Steele, I can continue if you'd like about Melnick. Okay. Yeah. Brian Steele also wants to have Mr. Melnick testify. Again, for your viewers, Mr. Melnick was Kenneth Copeland's attorney throughout, I guess, at least since the time of indictment, right up until he had to leave to, I guess, go on a pre-planned vacation after June the June the 7th. So, and it is crystal clear upon even reading portions of the, I think, public record, that at least what's been submitted to the judge, maybe it's not all public yet, but there was email exchanges between Mr. Melnick and the Miss Love, and the defense attorneys were on some of these emails. And Miss Love, in the course of requesting the ex parte meetings on the 7th and the 10th, misrepresented what was in those emails. And I think that rather than, we play a game of telephone where Brian Steele, asks Mr. Melnick for details about his interactions with the prosecutor's office, and then Brian gives them to the court in the form of a proffer, it would be much better for Mr. Melnick to just tell the court himself. So that is, I think, why Mr. Melnick will be in court on Monday morning, and hopefully the judge will hear what he has to say.
All right, I want to break down some of what you just said. So for those who might be new here or you may not be aware, when we lawyers use legalese, we use words that have a specific legal meaning. When we say Brady material it comes from the name Brady versus Maryland. It was a Supreme Court case that said the Constitution requires prosecutors to turn over information to defendants if it's information that reasonably could suggest that they are innocent. In other words, it points away from being guilt. It's the opposite of inculpatory. It's exculpatory information. So if you've got a witness who says in the presence of a prosecutor and even their own lawyer, that they're the ones that committed a crime that somebody is currently standing trial for, then that's obviously what we call Brady or impeachment material. So I wanted to kind of make that point, that's what we're talking about. So I also understand, Doug, that we're not sure if Melnick is going to be allowed to testify, but nevertheless, he's going to be there. What is the status of this? Is it a request? Is it a motion that he's subpoenaed to, or do you know?
I don't know if Brian has filed a formal motion. I believe he may be under a 2-hour subpoena, but I have not seen that. I'm just repeating what I think I heard stated in court on Friday. But But we have gone from the judge basically shutting down earlier in the week, ever hearing from Melnick, Mr. Melnick, to her at least opening the door to hear from Mr. Melnick. You know, it's interesting. The judge said something in court. I don't know if people picked this up, and it was Thursday or Friday, where she said she was talking about the things that she has to determine when deciding whether to grant my motion for a mistrial. So it seems that there were 3 grounds, if you remember. So the first ground was the inability to rewind and unhear the testimony of Kenneth Copeland. I think it's clear from everything that's happened in court, she's decided that that would not be a basis and that she can rewind. But the other was the ex parte meeting, the propriety of having that meeting, and then did Judge Glanville coerce Kenneth Copeland in that meeting? So with that background, she did say Thursday or Friday something that I'm not exactly sure that I agree with, which is that to her, and again, I may be perceiving this wrong, to her, the question isn't so much whether or not Miss Love lied or misrepresented to Judge Glanville, whether the ex parte meeting was necessary or what the reasoning was, whether the reason was right, but what did Judge Glanville hear? And based on what he heard, was it proper to have the ex parte meeting? I haven't looked into that from a case law perspective. It sounds incredibly nuanced if that's the way she's going to look at this, but that seemed to be a factor. If that's the factor, I would imagine that will be the basis she will use to say, well, maybe she doesn't need to hear from Mr. Melnick because whether Love lied or not to get the meeting maybe doesn't matter to the judge. I don't know. And we're all going to have to wait and see.
Well, let's say she does allow Melnick to testify under oath, and presumably he's going to come to court and he's going to say that, the prosecutors are making misrepresentations to the court or they're lying or whatever. Then we get in a situation where maybe they want to testify under oath because maybe they want to defend themselves. But I've always felt that we ought to get some of the people under oath who participated in these ex partes to figure out just what in the hell happened and what did we miss, because there's a lot you can't get from reading a cold, dry transcript. But let's say she does let Melnick testify, and he says, Judge, these prosecutors are lying to you. Okay. And let's say the judge believes him. Does she then remove the prosecutors from the case? What would she do, hypothetically?
I don't have an answer for that. I really don't. As you saw, for folks that maybe you can put this in your chat, but if you have it, she ruled against Brian Steele's motion and Keith Adams' motion to disqualify the prosecutors. Mm-hmm. And she discussed the high bar that you have to reach in order to disqualify a prosecutor. And honestly, after the last week, I did not read the full order denying Mr. Williams' motion to disqualify the prosecutors, but I think that basically the position is if there's any way to not disqualify the prosecutors, you don't do it. So I don't know if that's if she'll find that that's a grounds to disqualify.
Well, I've got a little bit more sound from Mr. Steele that I want to play. And once again, folks, turn your volume up, but then turn it back down when we come back. So I want you to be able to hear what he said.
And it said, I really don't want, as I told you, I don't want a mistrial. I just want to make it right, and I want the record to be good. So anyway, Mr. Melnick is going to take to task, and you make a credibility determination, Adrian Love, Jon Melnick's statements. He also adds that he states that he and his client, and he did not tell me, I said I don't want to know because it's attorney-client privilege, but he's going to work on it. He said, I assume that's a waiver. I'm assuming that with his client. He's saying that what Ms. Hilton said to the court and by both courts is not accurate also.
All right.
Then I have information that there's off so it's not in the transcript, so Mr. Weaver is either not there or definitely not recording it, that Mr. Copeland did talk about the killing of Donovan Thomas, said it's not on the transcript.
All right. So as I understand, so he's relating to the judge that he's talked to Melnick, and Melnick would prefer to, as I understand it, say these things in court. And it all has to do with things that Melnick, apparently, according to Mr. Steele, knows about the ex parte that he says that apparently Melnick, according to Mr. Steele, thinks has not been correctly portrayed to the court.
Yeah, I mean, that's exactly what he's telling the judge, and that is consistent with certainly the knowledge that I have, that there, as I said, there were things that happened in that ex parte meeting that were not transcribed, not because of any, I'm not alleging anything nefarious happened in them not being transcribed. I don't believe you had Judge Glanville. I think that would just be false to say Judge Glanville was sitting there, told the court reporter, stop taking down transcription of these events. But there was a meeting, as I said, where the judge wasn't there, and there was just an interaction between the state and Copeland and his attorney. So, and again, this Brady material, this obligation to turn over Brady material, there's been a consistent issue throughout this trial where the state has been reluctant or tardy to turn over Brady material. I mean, we had discovery, and one of the groups of discovery that came out late, that came out in July of 2023, that should have been produced in December of 2022. So 6 months into trial, one of the full file folders was labeled "Do not produce yet," or something to that effect. So if that does not show an intent to withhold Brady material, then I don't know what does. And anyway, it's a pattern. And as defense attorneys, Phil, we've made our request for Brady material. We should not have to keep beating on the door of the prosecutor's office or bitching to the judge that we need our material that they're obligated to give us.
Just flow automatically. Prosecutors know that they just need to hand it over. They can't sit on it. And look, the inclination is to, if you've got something that hurts your side, well, you don't share it. But if it's constitutionally required, that due process requires that the trial be fair, and it can't be fair if prosecutors are sitting on exculpatory information. So it's got to be handed over. Unlike, by the way, the prosecutors keep bitching that you guys are supposed to somehow turn over information out of your file, even if you're not going to use it in court. So,
right. Well, that's a nice, I don't know if you intended that to be a segue to Ms. Love's request, citing alleged case law that would support her position that we're supposed to turn over discovery at certain points where, in fact, we're not supposed to produce discovery yet to her, or not required to.
Yeah, I mean, feel free to get into that. I've got some video on that I, in fact, I can just play it real quick if you want me to. Let's see.
Sure, it felt like that was your intent.
That
as to the
issue.
authorship of this particular motion, and to
This
have
right video,
whomever authored this motion be present in court. The response I got back was Ms. Love saying, "I will be present." Does that mean, Ms. Love, that you are the author of this motion?
Yes, Judge.
Okay. So I have some problems with some of the representations made in this motion. Specifically on page 3, the citation to U.S. versus Young, and then to U.S. versus Waddell, and then the statement, quote, a defendant has a duty, underlined, to disclose prior to trial and an ongoing duty to timely disclose, in bold, any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence. See id, meaning see the above two cases, Waddell and Young. I've read both of those cases. Show me in either of those cases where there is a proposition that discovery and reciprocal discovery obligations of the defense applies to evidence that's going to be used solely as impeachment.
Let me pause it for a second. Okay. So Georgia, by way of background, has something called reciprocal discovery in criminal cases. By the way, Doug, we played a clip of you the other day in here where you were pointing out that, you know, if this were a civil case, you'd have much more discovery tools available to prepare for trial. But in Georgia, we have what's called reciprocal discovery in criminal cases. And there are certain things, it's reciprocal because some things have to be exchanged from the prosecutors and some things by the defense. More things by prosecutors, less by defense. But nevertheless, we do have certain obligations to hand certain things over. But it's limited. So before we go ahead with this video, Doug, tell me what we just heard the judge talking about.
Yeah, this is a highly unusual, thankfully, thing to ever see in court. So by way of background, the judge's chambers had sent an email, and you stop me if this goes on too long, Phil. But the judge's chambers sent an email to the prosecutor and said, I want to, and we were copied because there's no ex parte communications.
Right.
I want to see whoever authored this motion. Forget who signed it. I want to see whoever authored this motion in court tomorrow morning. Now, why, people were asking, what's this business about authored? She signed it. Certainly she authored it. Well, as you and I know, outside of maybe the criminal defense practice where we're usually solos or maybe have one other person helping out, in the prosecutor's office, in large, medium-sized law firms, in big law where I spent most of my years of practice, it's often the case that a more junior person will do at least the initial drafting of a motion, and then perhaps a partner might clean it up a little bit. There's different practices, different places, but the person that signs the motion is not necessarily the person that authored the motion. However, it is true that when we sign a motion, by rule, we are attesting that, to the best of our abilities, what we're signing is true. So anyway, I saw that email, and the only other time I've seen that type of email twice before from federal judges. And in both cases, it was to call a lawyer on the carpet for something. And sure enough, that's what you see here. We have Judge Whitaker, a very scholarly, intelligent judge. She spent years as an appellate lawyer. She, in conjunction with her staff, are going to look up these cases that you cite to her. And here we had a circumstance where the two cases that were cited by the prosecutor to support this false rule of law did not support that false rule of law. And Judge Whitaker is about to take Ms. Love to task for that.
Okay, let's play a few more moments.
I didn't say solely as impeachment. I said as both impeachment and as substantive evidence.
Which implies that the use of it as impeachment evidence triggers the reciprocal discovery.
Did you want me to pause?
No, I just said just keep on digging. Okay. Go ahead.
No, unless I wrote it inartfully. What I was saying.
Well, you wrote it inartfully.
I did then, because what I was saying was that it has to be both. That is the representation that
all right.
I made. And then when I amended it,
I didn't see an amendment.
I have a copy for the court.
Did you fix that?
What I did was
Thank you.
Sort of elaborate.
Okay, so reading between the lines here, she got that email saying that she wants the author of that to be present in court, and she's like, "Uh-oh, now I got to clean it up."
Yeah, what a terrible position to be in as an attorney. And if I can have a moment to use this as a brief teaching moment for
Please,
new
that's why we're
attorneys
here
that
to
may
learn.
new attorneys that may be watching this. I saw kind of a variation of this in the Eastern District of Virginia in 2006. So you see it really, even though it didn't happen to me, it left quite an impression on me, where it was the two top intellectual property partners of a AmLaw 100 law firm, probably an AmLaw 50 law firm or 20 law firm, one of the top 20 law firms in the country, had filed a brief. It was an opposition to a motion for sanctions that I had filed, where they had flat out lied to a judge in the Eastern District of Virginia, where the judge had, in an ordered a deposition of a party. The party didn't show up. I filed a motion for sanctions, and in opposing it, they said, "Well, Judge, you never ordered that." And what had happened was these partners were in California. The case was in Virginia. They were not Virginia attorneys. So they had to get a Virginia attorney to sign off on all their pleadings. So they had a poor first-year associate in their Washington, D.C. office sign all their papers, but not read them. Now, look, even though you're just a first-year associate, you're supposed to read everything you sign.
In Georgia, you're required to, right?
Yeah, you're required to everywhere. And this judge ate that poor associate alive. If you sign a pleading, even if a partner gives it to you, if you sign something, you make sure what you're telling to the court is accurate and a fair and proper representation of the facts and the law. Now I forgot where we were, but
well, we'll keep going, and I'm not going to play all of this, but
yeah.
There's a point where I'm going to stop it, but I'll point it out when we get there.
Right on it, or yes,
and we can talk over it too.
Yeah.
So you concede then that if evidence is going to be used solely as impeachment evidence, that there's no triggering of a reciprocal discovery obligation?
Yes, that's not. Yes, I was not saying that. I was saying
good to know.
My apologies to the court for that inartful wording.
Okay.
And what I said in the amendment, Your Honor,
the CYA amendment.
Did you email the amendment to my chambers?
I did.
Okay.
Yesterday, I believe.
Yesterday. Okay.
Yes,
well, that may be why I hadn't seen it, although I've been looking at y'all's stuff nonstop. Okay.
That's a true statement.
It's in front of me now. So.
So what our position is, Your Honor, as I state on page 3 of the amendment, is outlining what Georgia's statutory requirements are. Of course, the court is aware of what OCGA 1716 4C1 requires.
It's about to get worse if that's possible.
Then I go down to subsection C on that same page where I cite Aggie versus Estate 311 Georgia 340 at 343 and go on to say Georgia's discovery law does not explicitly apply 1716 4C to evidence used simply for the purpose of impeachment.
Okay.
And then I say it unquestionably applies to that second intended purpose, use as substantive evidence. And then in section D, Your Honor, I cite to relevant similar federal laws, pointing out that federal law requires the defense to provide the government with materials that are within the defendant's possession, custody, or control. Possession, custody, or control. My apologies. Where the defendant intends to use the item in the defendant's case in chief at trial. And that's Federal Rules of Criminal Procedure 16B1 alpha.
All right. So it can be used in the state's case in chief and maybe be impeachment evidence, maybe be substantive evidence, maybe be both. It's not where in the trial it comes in that matters. It's whether it's used and intended for use as substantive evidence or not.
Yes.
Okay. So as long as we're all on the same page with that, and I actually do think that to the extent anybody might want to take a closer look at what those distinctions are, I think it's Waddell,
Yes.
where the court actually says, hey, you know what? These can be tricky. These can be dicey. Here's what it means. Here's the difference between the two. So I would recommend for everybody's reading pleasure the court's exposition of that issue in the Waddell case.
And in that amendment, I did correct
All
the
right.
Waddell site.
Okay. All right. So
Doug, you got something you want to say?
Yeah, I'm trying to tell my wife that there's an Amazon package outside
Oh.
the front door.
we'll follow that law
sorry
as
about
well.
that.
The legal analysis is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it because she sat here in court and I did the same thing without being tempered.
That law as well.
I want to see that again.
Thank you for clarifying that.
Is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it because she sat here in court and I did the same thing without being tempered.
All right.
That's 4 times.
Court correctly pointed out earlier.
Skip to the end.
Said that the basis for what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is stuff that we are entitled. And Mr. Steele has said no, in citing the Georgia statute. He said we do not. I have never asserted, I've never made this distinction. I've never said that case in chief means if it's being presented as impeachment as substantive evidence. I've never made that. I've never made that argument in a written or oral filing.
Okay. All right. Well, I would like for you to take your duty of candor to the court with a little bit more seriousness.
And with that, when a judge tells me that I need to take my duty of candor more seriously, I don't know that there's much worse of a thing as a lawyer I could hear a judge say to me.
It's
honestly.
It's a very difficult position to be put in as a lawyer. You should never put yourself in that position. It's something you never want to hear. It's right up there with as harsh a thing as a judge can tell you that I can think of. And I think if I wouldn't have sat through the last 18 or 19 months, I would feel more for Miss Love. Even still, it's such a harsh thing. Even after all we've been through, I still feel a tiny little bit. I mean, that's just painful. It's painful to watch that being told to another lawyer. It is. It's cringeworthy. It's very, very tough. And
Doug, go ahead.
Yeah. And so what you heard, the frustration from Brian Steele was this was the 4th time he had made this argument to the court, 3 times before a previous judge. Here he was having to do it again. I think the difference is this time we've drawn a judge that really comprehends the distinction. And I don't think Brian's going to have to do it for a 5th time.
So I know that your time here is limited, and
I've had a change of plans. If you need me for a little longer, I can keep going. It's up to you.
Right. Well, there's just some questions that have been asked that I thought you and I might try to answer together. Melanie asks, does every ex parte require notice to the other parties not present? Yeah, I think it does, right?
I think it does too. What I was trying to find case law for under Georgia law is whether that notice had to be prior to or immediately after the ex parte takes place, because I I think there's an argument that it should be prior to the ex parte occurring, but really it happens all the time where it's after. So probably either way is okay. I couldn't find any case law that really put it there. But there's certainly, here's the situation though. There's certainly times where you definitely practically, for what you're trying to accomplish at the ex parte, can't notice the other party before. In which case I believe you should notice them immediately after, rather than what happened here, which is everything possible was done to keep the ex parte meeting a secret, right? I mean, I don't think that's my imagination.
Now, this is I'm going to ask this, I'm going to show this question here. Miss Love was using AI legal in court the other day. Can she do that? Before we respond, Doug,
Yeah.
I want to add to the stage. Now, this is the X feed for looks like the Black law student posted this. So let's play this and make sure everybody can hear it. Let's see.
And that would be and that would be
all right. So
Okay.
he says that I know that site. So, Doug, what's going on here? Is this of any significance? Is it a red herring, or what's going on? If you know?
Well, I think it's a giant nothing burger. I don't care what she's using on her computer. I don't care if it's AI, if it's a link to a Google quantum computer sitting in California, figuring out the law. I think this comes back to something we discussed earlier, which is when you make a representation to the court, you have an obligation as a lawyer that you make sure that representation is accurate. So if you're using an AI tool to find cases, to generate briefs, whatever it may be, I actually personally don't think, at least in Georgia, there is anything against doing that.
Not.
The key is that you just insert your brain between whatever tool that is and what you provide to the court.
Yeah, there's no real rule against it, but you got to be real careful. You can't just have AI spit it out and then just sign off on it without checking it. That would be highly irresponsible and could get you in a lot of trouble.
Yeah. And look, as someone who has written scores of patents related to artificial intelligence, I can tell you that these large language models, I don't want to get too technical, but these AI tools that people use, they're not really intelligent. What they do is they look for patterns, they gather data, and they reproduce results based on patterns. There is a learning that takes place, but it's not the same way that our brain works. But anyway, yeah, I think whatever tools lawyers want to use, whether it be Westlaw or Lexis, I mean, it's changed a lot since law school days, right, where you had to do everything on paper with books and everything else. So whatever tools are fine as long as you think. And I also am a little I'm perturbed that her computer was picked up by the cameras. I just don't think that was appropriate. But of course, as I think I said in a tweet, she can do what I do, which is to use a privacy screen or something to that effect. But yeah, the cameras really shouldn't be picking this stuff up.
I agree.
And then you as the lawyer should be doing what you can to kind of guard against that. But there's a trade-off, right? And the trade-off is they get proximity to the jury, which breeds some degree of affection, according to all the psychiatric studies. But I guess in this courtroom, in exchange, they've got that camera staring right down upon them that we don't have.
So Melanie Snare asks, can they use Freedom of Information Act, or Georgia we call that Open Records Act, for, I think we're talking about things that maybe were emailed between Judge Glanville and the prosecutors. That's what I think, Melanie, correct me if I'm wrong, but that's what she's asking. I don't know I know you can open records. Any county-owned device, because if you generate a text or an email on your county work email or anything like that, it's subject to it. But there's also exceptions to the rule that mean, like, things that are currently under investigation, for example, by the government, they typically will exclude those. Doug, your thoughts?
Well, I don't know much about the Open Records Act, and
Yeah.
I am going to be cautious about speaking about things that were not done in court, at least as of yet. But we, as officers of the court and participants in this trial, have other methods available to us to gather communications that may or may not have occurred. And so that possibility is always out there for us to use to gather information that the public might want to use the Open Records Act to get. How's that?
All right. Fair enough. Thanks for the £2 super chat. It looks like the judge wants this done in 3 months. Has she said that?
No, but I think she has made allusions and references regarding certain timeframes that you could easily infer from that she expects this trial to wrap up, by the end of the year. I think. I think she has put some things about months out there, but she hasn't said, no, I expect the trial to wrap up in 3 months. But I do expect her to, and she's already begun to do what I've already asked her to do, what I asked Judge Glanville to do in April, which is ask the prosecution, give me a list of witnesses. Let me know what they're going to testify to. And I, as a judge, maintain the right to not have repetitive testimony in my courtroom. So I could easily see her striking witnesses and trying. She's going to keep this trial moving. God bless her if she wants to finish in 3 months. I'd love to finish in 3 months.
You do.
But we still have to put on our case, or we don't have to. We have the option to put on our case. So I'd love to see the prosecutors wrap up their case in 2 or 3 months and then let us take the floor for a change to the extent we feel that might benefit our clients. And my current personal guess is we're done by the Super Bowl of 2025, given this particular judge.
You heard it here first, so
right.
We'll see. You can come to my Super Bowl party. I mean, well, you can come either way, but hopefully you can come to my Super Bowl party a free man, free of all of this.
Well, I've got 60 trials backed up that every judge in Georgia is going to jump on me for as soon as this is over.
Surely not during the Super Bowl. Anyway, hopefully you get some time. All right. So real quick, this was filed late in the day, 4:06 on Friday. This was this is what Max Shart filed on behalf of Shannon Stillwell, a renewed motion for fair and unconstitutional. Look, I don't know why it's necessary, other than this case is the only time it should never be necessary to file a motion, let alone have to renew a motion for fair trial. But anyway, that's what he does. And he goes on. I'm not going to go through all of this, but I think one of the moderators has posted links to it, and it's available online as well. Prosecutorial misconduct implicates a criminal defendant's due process rights when it renders the trial unfair. To the extent that this trial has failed to meet those constitutional requirements in the past, Stillwell demands this court take appropriate actions. Now, he doesn't immediately say what the actions are that he wants, but he does say that this has been plagued by discovery violations, lost and missing police reports, and Brady violations. We talked, Doug, about Brady violations. Do you have any examples of discovery violations from the state that you've talked about in court?
Sure. I have many examples of discovery violations I've talked about in court. Georgia law says that unless a judge orders otherwise, discovery from the state needs to be produced 10 days before the start of trial.
Which is ridiculous, by the way. It needs to be much.
I know. I mean, practically, for people watching, practically, we do get it right. We do get it much before that. But at a minimum, 10 days. That's the law. That is the law. And repeatedly in this case, in January of 2023, February, March, April, May, June, July, huge terabytes of new discovery was produced to us months after it was supposed to be produced. So those are discovery violations. And, you know, Judge Glanville would wag his finger at the state and say, hey, you know, if you guys keep doing this, I'm really going to do something one day. And we've had trickles of discovery. This is, by the way, discovery that they have had. I mean, we had some discovery come out to us just a couple of months ago that they have had since, I think, 2017, and they just produced to us. So it's a constant issue in this case, and I find it infuriating because I think, as folks that watch can appreciate, it is very difficult to review new discovery when you're in the midst of trial for any number of reasons. Time constraints, the fact that your approach to certain witnesses may be different. There's just so many different avenues. So late discovery is an issue. Late production of Brady material is an issue. What Max Shart is referring to is that there have been issues where we have not received police reports that we believe they must have. Now, they'll stand up and say that they don't have them, but it just doesn't, it's simply not credible. And so we haven't received these reports. And despite Judge Glanville sitting up there and telling Miss Love, hey, you know, I've seen Fani Willis in here litigate, and she'll turn over the whole file to the defense. And Fani Willis will say, you know, if I can't beat them when they have my whole file, well, then I don't deserve to win. And he would say, Miss Love, you need to do the same. But as I've said in court, I don't believe they have done the same, and I don't think Max Shart believes that they have done the same.
Well, speaking of Max Shart, he also refers to an incident in 2023 October. Glanville started a contempt hearing against him, and says Glanville sent deputies to find him at lunch during lunch break and summoned him to chambers. And a courtroom deputy told him that Glanville was expecting an apology for Shart allegedly calling him some, looks like maybe it's bull something, BS in open court. Counsel was advised that he should, I guess he's advised by the judge that he shouldn't deny it because it was all captured on video. Come to find out, it wasn't captured on video. Glanville tersely told Shart to leave his chambers, and later in the day started a contempt against him. He berated him. He threatened him with jail. The Glanville accused the undersigned counsel of violating bar rules, putting his law license in jeopardy, for lying to the tribunal and not confessing his sins. And he points out down here in footnote 2, the press was not filming that day, so there is no video of it. Yeah. David Botts, who was seated within feet of Max, spoke up and told the judge that Max never made such a statement. Of course, the video that, quote, captured the event was never produced and no apology was made. And he goes on to talk about, on different occasions, he baselessly called Brian Steele unprofessional and unprepared in front of the sitting jury. And I remember seeing some video, Doug, from Brian Steele was absolutely apoplectic because he's not somebody that's unprepared.
Never unprepared. And so to take, Max and Brian are there every single day. They are fully prepared. And so to say that about Brian in front of the jury was, I don't want to use too strong a term, but just, it was out of bounds. It really was out of bounds. And I don't know why Max Shart was Judge Glanville's whipping boy for most of this trial, even during the motions process. I think you can see, if you go to Thugger Daily's Twitter feed, he puts up, I think, the earliest known televised instance of Judge Glanville being harsh to Max Shart. And it was during some type of motions hearing back in 2022 when people weren't really following things.
I think I may have some video that's relevant to this. Let me see.
Judge Glanville,
Sir.
you allow another moment when Miss Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful, I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8, after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They have everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time.
Okay.
And I apologize that I'm getting tempered, but I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Your Honor, could we strike the
No,
hominem
I'm
attack?
speaking.
Really, could we strike that?
Okay, hey, everybody,
Sit
calm down. Everybody,
This is me
both of you
false.
please be seated.
Judge, I'm not
Both
done.
of you, please be seated.
You have to do something. You have threatened me with contempt. You have threatened me with jail. If you go back in time, we can just start in voir dire. Jury after jury, you did individual voir dire painfully. Miss Love would come in and say that juror was crying. It was not true. You would say, that's not my recollection after I said it. You did nothing. We start the
Okay, but
case.
Mr. Steele.
I asked you, please.
Mr. Steele.
Please, Judge, how would you feel if you were being treated like
Mr.
this?
Steele. Mr.
Well,
Steele.
I'd like to finish.
Mr. Steele.
I gave them everything on that drive, and it's continual abuse of a prosecutor of another member of the bar. I don't talk.
Yeah. So, I mean, that's just an example from a few months back where Brian was just at the end of his rope over the same kind of stuff.
And I think folks that don't know Brian or Brian's reputation cannot appreciate the level of disrespect repetitively hurled at him that it took for him to reach this point. That is not something that you're ever going to see at a Brian Steele.
And this is where Max, in this motion here, he states the state intentionally and erroneously accused Steele of tampering with and altering jail calls made by Kenneth Copeland, which were served in reciprocal discovery. That's what we just saw. That was when it happened. Of course, these heavy accusations were entirely false and without merit. But as Max points out, there were no consequences for making wild, false claims.
It's all true.
Yeah.
Everything in here is true.
This is a long motion and we won't go over all of it, but part of it I wanted to point out. The state falsely characterizes the meeting, the ex parte meeting on the 10th, that would have been the Monday, about a grant of immunity. And I've always said they've mischaracterized it. That's how they're trying to claim that it was justified, is it was a hearing on immunity. But as Max points out, I don't know, maybe he watched this show one day when I said it, but I'm sure he figured it out on his own. The reality is that Copeland had already been given derivative use immunity on June 7th. And so there was nothing else for the parties to discuss regarding the grant of immunity. So their whole reason, and Fani Willis in her brief asking that her prosecutors not be booted off the case, she also made this same claim. And I think it was false.
Yeah, I think that is not an accurate representation of the circumstances. It's just there's been an avalanche of this from the state, and it is exhausting, taxing. I think people who are not attorneys maybe don't understand that there is a level of professional respect between opposing counsel particularly in criminal cases, even more than civil, but even there's a level of respect and almost friendliness between prosecutors and defense attorneys. I mean, for the most part, we get along. This is not the norm, what you're seeing here. This is the exception. I get along perfectly well and make small talk with a lot of prosecutors in there that isn't caught on camera. So this situation is it's just insane, and it all stems, well, as Brian said. Brian said there's one lawyer that this comes from in that courtroom, and I think he's right, and there's never repercussions for it.
Well, just to get a little bit more into this pleading from Max, he says, and he moves into the June 7th, the Friday, which was the second one that we learned about. And it says included Love, Hilton, and Glanville. These communications and the substance thereof have never been disclosed to the defense until Whitaker released a transcript. While the parties were well aware that Judge Krause was considering the advisability and potential implications of the June 10th ex parte as part of her considerations of motions to recuse, he says, upon information and belief, and by the way, folks, when you hear a lawyer say upon information and belief, that's the lawyer saying to the judge that this is information that the lawyer has come into possession of somehow without further need to say where it came from. But it's basically you're saying that you've got a good faith belief for what you're about to write. Neither the prosecutors nor Judge Glanville ever revealed to Judge Krause that there was, in fact, another ex parte that had occurred 3 days prior. I mean, it would seem to me that Judge Krause should have known that there was another one. And since the only people that knew it were the prosecutors and the judge, they had some duty to Judge Krause. That's just my opinion. Yeah. He goes on to point out that the transcript of the June 7th ex parte is shocking. The meeting was initiated by the state. The meeting of itself was illegal. In that meeting, the state intentionally and wrongly attacked the character of Copeland's attorney, Jon Melnick, claiming that Melnick was not representing Copeland's interests. And this, Doug, is part of why I think she might let Melnick testify Monday morning, because Melnick was all over that transcript. His name was, anyway. He wasn't there. He was, as Max points out in a footnote, he was on vacation in Alaska. Something, by the way, that they should have worked around his schedule. It's just common decency. Lawyers do it all the time. Judges do it for lawyers all the time. We try to work together to accommodate schedules and leaves of absences when they're granted. So they should have worked around his trip. But anyway, they during this ex parte, they claimed that Melnick was not representing Copeland's interests, but Copeland was, in fact, representing the interests of the various YSL defendants. And Max says that the state besmirched Melnick to Judge Glanville without cause, all because Copeland was not interacting with the prosecutors the way they would have wanted him to. Prosecutors claimed to be the only ones who were truly representing the witnesses, quote, our witness. So prosecutors claim to be the protector of Mr. Copeland, which is interesting. So they're talking all about him behind his back. And, he goes on to point out that the state in that meeting could not be concerned about the possibility of Copeland suffering an unjust jail sentence due to it says Melnick's interference in his client's affairs. What they mean by Melnick's interference in the client's affairs, Melnick is the one that advised him to take the fifth, which was his job to do, which is the right thing to do. So they're claiming that is meddling in Copeland's affairs. Upon information and belief, Attorney Melnick had already purchased non-refundable tickets for a trip to Alaska, which was to commence that coming weekend. Perhaps if the state had not cut out Melnick from their communications with his client, he would have been able to schedule his trip accordingly. And this is out there. I would encourage anybody to take a look at this. He goes through a lot of facts that we've already talked about. But what I'm going to go to that he's asking for real quick before we finish with this, Stillwell has been harmed by judicial misconduct, prosecutorial misconduct, and other error. It says he does not demand a mistrial absent a finding of goading and thus jeopardy attaching. So he does want a mistrial if it was goaded into it. But he goes on to say, carrying on with this trial as if nothing improper happened is also not an acceptable option, which leads me to wonder, okay, well, what is it that you want? Well, he does tell us here in conclusion. It says appropriate remedies must exist. Possible remedies include, but are not limited to, disqualifications of the prosecutors, which she's already denied once, but presumably she could revisit that. So disqualifying the prosecutors involved in this misconduct, the dismissal of this indictment with prejudice, which is essentially the same thing as a mistrial with prejudice. Instructions to the sitting jury explaining the situation in full candor. And then he goes, and or mistrial. So here he is asking for a mistrial with a finding that the mistrial was caused by judicial and prosecutorial misconduct. So that's the essence, if you will, briefly, of what Max is asking for. And so, Doug, before we started, you told me that one of the issues that remains, if there's no mistrial, is what is the judge going to tell the jury as far as instructions? Will the judge do what Max asks and give them the full unvarnished truth, or will she do something else?
Now, I believe the judge has already, I don't know if it's a final order, but at least an indication, if not a final order. Well, I think she's still weighing it, but I don't think the judge is going to go into this level of detail. We have basically asked the judge to tell the jury that the judge has been disqualified. We don't believe there's any reason to hide that from the jury. He's been disqualified and can no longer sit. I don't know what she's going to do as far as the level of detail. I don't think she's going to go into that much detail. And so you have you have a situation where I've asked for a mistrial regardless of whether double jeopardy attaches or not. I believe double jeopardy should attach. I believe it's because we were goaded. I believe that's the only proper remedy. I believe that's the correct remedy.
You think she's going to say he was removed from the case, or will she say something watered down like we've had a need to have a new judge come into the case or something?
I don't know. I don't know exactly. I don't know. I don't want to predict, but I think it's going to be fairly soft.
So I know there's also plans to poll the jury, POLL, which presumably would be bringing them in one at a time into the courtroom and asking them, since they've been gone, so to speak, have they learned anything about this case in the media or here on YouTube, or are they watching my show, things like that? How's that? How do you think that's going to go?
I don't recall hearing plans to poll the jury. Maybe it could be that I was zoned out during that point of trial. It's been a long week and I'm tired.
Well, I mean, to me, I think it would make sense to poll them. I don't know how many alternates there are. Is there more than two?
I prefer to not discuss the possibility of polling the jury.
All right.
Well, yeah, I prefer to not go there. I don't know. But I will say I haven't heard that in court yet.
They were instructed, as all jurors are, not to pay attention to news media or research the case or talk about the case or anything like that. So presumably, and they are presumed to follow instructions, but we all know that jurors don't always follow instructions. So, and you don't have to comment. I respect your, I respect the position that you're in. It's been posited in public discourse that if a number of the jurors have been tainted, so to speak, by not following the instructions and hearing or watching things about this case, then perhaps we might not have enough alternate. What would happen if enough jurors, had been exposed to media information or public information about the case, and we can just leave it there. We don't have to talk about it, but that would certainly present an interesting quandary that the court and the parties would potentially have to deal with, but maybe not. Hopefully they follow the rules and we won't have to have any kind of discussions on that.
I will say in general, I don't believe that the remedy to what has happened in this case is for there to be a mistrial with the state allowed to learn from all of their mistakes over the past 7 months, all of their experiences, whether they were mistakes or not, and then take a second bite at the apple and, retry this case and do a better job of it the second time around. Now, I think given the evidence in the case, which is what it is, it's not going to change in a second trial. Given the way witnesses testify, it's what it is. It's not going to change in a second trial. But if there is a second trial, we'll be in the same position we're in now. But from an inherent fairness standpoint, does anyone who looks at this case think it's fair to retry my client, given all the misconduct that's occurred? And I feel for Donovan Thomas's family. He's a murder victim. I feel for anyone involved as a victim in a case where there's a mistrial that they feel, and especially one where prejudice attaches, that they feel perhaps that they didn't get justice. But when that happens, the blame does not lie with us on the defense. The blame in this case lies with Fani Willis's office and I believe the judge, who ultimately is in control of that courtroom.
Lloyd Barnes asked the question, Melnick wants the opportunity to confront the state and also Judge Glanville about their handling of his client. Well, so Melnick is not a party to the case, so he can't really, he doesn't get to call witnesses. He used to represent one, apparently. I guess he's no longer does represent Copeland. But in any event, if he does get to come as maybe Brian Steele's witness and have his say, so to speak, to defend himself, the second part of Lloyd's question is, does Whitaker have the right to deny or approve that? And the answer is yes. She can let it happen or not. It's almost entirely within her discretion.
She has a lot of powers here, but I think the judge's attitude towards a lot of these issues of unprofessional conduct is to say that in many of these cases, this court, and she has said this trial is not necessarily the proper avenue to pursue justice, remedies, cures in those instances, that the state bar, perhaps the Judicial Qualification Commission, those may be better avenues to seek redress of those grievances.
Yeah. All right.
So that seems to be her, that's a side issue in some cases to her. Now, we don't believe it's a side issue, especially when it comes to issues of the conduct of the state.
Well, Doug, you've been at it with me now over an hour, and you got a big day tomorrow. What's looking forward to next week? Briefly, what do you think we can expect? I mean, we don't know if Melnick's going to testify, but and we don't know how she's going to rule on your motion. But what's the rough plan for the week, if you know?
Well, I expect we'll see a ruling filed in the morning on my motion for a mistrial, if she has been working on it all weekend, which I perfectly accept her at her word. She said something to the effect of, it's not just you attorneys that work weekends. We judges do it as well at times. Yep. So I think we'll all see. So that's something to really see. I'm going to be fascinated if she rules, if she denies my motion, how she goes about doing that. She's, as I said, she's really, I don't want to say she's an academic, but she's a practiced appellate attorney. So I think it'll be thorough and well thought out. And I think that while I might, if she denies my motion, I'll of course disagree with her. I imagine there will be merit to some degree to it. So we have that in the morning. We all get to see whether she allows Mr. Melnick to testify. So I would be glued to my stream to see how that comes about. And then a big part of Monday and Tuesday will be figuring out How are we going to tell the jury? What's the process that we'll use to tell the jury to ignore the testimony of Mr. Copeland on the 13th, 14th, 15th, 13th, 14th, 15th, 13th, 14th, and 17th, I think. Those 3 days plus a little of the 12th. How are we going to do that?
That was the time period.
I don't think it's
when
possible.
Glanville should have stopped and sent the motion to recuse out. But between that time and when he actually did it, there's that period of time where basically everything's a nullity.
Right. We're only in this fix because he continued. But so we're going to have to see what she does about that. She has opened the door to allowing the defense and the state to, it sounds like, stipulate perhaps that portions of his testimony after that date can come in. I'm not sure where I fully stand on that yet. I just know the law says it's a nullity after I made my motion. So yeah, we'll have to see. There's a lot, and then of course the jury is due to come back on Wednesday, and then Mr. Copeland will be on the stand, and Miss Hilton will not be the one doing the examination because she is going to be out. I withdrew my objection to another member of the state taking over that questioning, so someone else will be questioning Mr. Copeland.
All right. Well, there you have it. I want to see a big round of applause from the chatters in here. And for Doug Weinstein, thank you for spending so much of your Sunday. I know you got some trial prep to do, so I want to give you the time to get to it. But I want to say again how much I really, really, truly appreciate it, my friend.
And before I leave, let me pitch the Twitter Spaces that myself and Suri Chada Jimenez will be doing tomorrow night at 8:00. That I will be hosting, where we're starting up this new Monday night Spaces that I think will eventually morph into some form of podcast where we discuss prosecutorial misconduct across the U.S. So we're going to be focusing on the Miami State Attorney General's office and what happened down there over the last 2 years. So that's what we're going to be talking about tomorrow night.
No shortage of material to talk about in that department. Yeah, thanks for that. I'll make sure to check it out. Hope everyone here checks out Doug's Twitter space as well. Now, send me the link to it, and I'll tweet it out tomorrow just to remind everybody.
Thank you, Phil. I'll do that. And thank you for having me on. It's always a pleasure to get these great questions.
Big round of applause. Good night, Doug. Man, I tell you, I can't begin to say, folks, how grateful I am to that man for spending so much time to come here inside the law and help us understand what's going on, because there's a lot of public discourse. There's a lot of people talking about this on YouTube, on Twitter, and every place else, and it's not all accurate. So when you hear it right from the horse's mouth, so to speak, from one of the players, the major players who is in that courtroom, then you know you're getting the good stuff. You know you're getting accurate information, and you have hopefully an accurate and better understanding of where things are in this case and where they are going. And thanks to all of you who are here live and, of course, on video replay. I really appreciate all of your support. And look, as we always, want to remind people, no matter what you do in life, don't be this guy.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lies.
Yes, you man. We're gonna take a break soon. Hang in there.
He ain't gonna tell you no lie. Look, until next time, I'll see you right back here inside the law. Thanks, everyone.